My name is Dolly Prosper. I am a band councillor for the Paqtnkek First Nation. The purpose of this video is to inform members of the Paqtnkek community, both on and off, in regards to the matrimonial law. This law, federal law, is going to be enacted December 16th of this year. It's a law that really gives federal courts the power to impose decisions relating to unreserved. And I guess the obvious question is, what does this law mean as it pertains to First Nation communities? It allows the courts much broader power when it comes to occupancy of band-owned homes, who occupies these homes, and the duration as to how long, especially in a case where non-band members would be able to, in terms where indefinitely in some cases. We understand that it's going to be enacted or in place December 16th. So what this means is that unless our communities, First Nations community, comes up with our own law, the federal legislative law will apply. The Confederacy and Mainland Acts have the board of directors, that is, has decided to be proactive and develop a committee that would look at developing a law that would reflect the needs of the First Nation communities. The chief and council of the Paqtnkek community had decided that I would be the rep. The overall goal for the committee in drafting our law, or the law that would pertain to First Nation communities, would be more or less just to expressively protect the band-owned homes, to protect the occupancy rather than impose in federal court law. This team or committee met at least 6 to 7 times over a course of a few months from September to date, in preparation and developing a draft law. First and foremost, we wanted to develop a law that would protect the band member, and especially the First Nations children of our communities. We certainly want it to be our decision. These are band-owned homes. They're a property of the band. We certainly don't want to see federal court coming in and imposing their law for a number of reasons. They are not there to protect, but more or less to impose, to impose power. We have First Nations government in our communities that are subject to determine, and we want to continue to determine these type of rules or laws. And primarily, we want to be able to do this to protect our band members and our First Nations children. We here in the Paqtnkek community had brought forth Mary Jane Abram, being a legal advisor for the Confederacy, as well as Brina Fraser had. These two lawyers were playing the lead in assisting us in developing this draft law. We brought them in to provide some information on what the federal law, matrimonial law, real property law was about, and to introduce our draft law, and just how it would play out as far as the differences between both. We have directors meeting, on average monthly, and it was just to bring it forward to the directors at first. We brought in our housing committee at the same time, and just went through an information session as to what it all meant. What is the law, what it means to the community and its members, and as well as to what our draft law was about. There's fear, certainly, because we do have occupancy of families where there is a non-member and member. And I think one of the biggest fears is, well, God, if something happened to me, if I, for some reason passed away, or then what happens to my children? I think that is one of the biggest fears, is that their spouse would be removed from the home immediately, and that would not be the case. And the reason why that wouldn't be a case is because the draft law we're looking at, protects the child. And by me saying that, it allows the non-member parent, to occupy the home for the duration up to when this child or children become of age. Pertaining to the federal law, what is creates some concern certainly is the when a non-member occupies a band-owned home, in the event that a band member, partner, or spouse has passed away, the federal court would be able to pass where this non-member would have exclusive, or when I mean exclusive, I mean unlimited amount of time, or indefinite amount of time, to occupy the home. This certainly poses a problem for our community in more ways than one. It's certainly the upkeep and maintenance of the home who would be responsible in a non-member situation. It doesn't only reflect just occupancy, but also the administration of that home itself, where it's a band-owned home, the particulars of sustaining the home, heating the home. They could live in this band-owned home forever. Many of our First Nations communities are in a situation where housing is an issue, where our waiting lists are beyond. Our proposed law would have timelines in regard to that occupation of the home. If there were children, custodial, if the parent has custodial a parent, this parent could have occupation for the duration as long as the child turns 19. The process we're using or going with is that we will be having a community information session pertaining to the Matrimonial Real Property law, December 2nd. It's an opportunity for community members to engage in what it means, some changes that could be applied to the draft. It's not in its final stages, but it's just an opportunity for members to find out what it is and how this draft law would apply in difference to what the federal courts are imposing. We're hoping that we'll get great participation in this, and from that, this draft law will be going to a referendum. When I'm talking about referendum, this involves both on and off reserve members, and package is being compiled as we speak with the Confederacy Mainland Micmacs, and will be mailed out. We will be having a voting day here in the community for the on reserve, or for any off reserve that is able to travel, and that will be held on December 17th. It's really, really important that we as First Nations community enact our own law. It would be a law that's developed by us, for us, and most importantly for the well-being of our community members. It's imperative that we do. I mean, if federal court is in a position where they can make law on reserve in regards to assets that are really subject to First Nation that is something that is going to be a scary thing. We as a First Nation community want to be the ones that decide